Yo, family, what's going on? What's going on? How y'all doing? How y'all doing? So look, I made a video about this before, right? And I want to explain something to y'all because I've been seeing a lot of my Moorish brothers doing it. I've been seeing a lot of sovereigns doing it, right? Never exhaust all remedies after trial. And some of y'all make the biggest mistakes by doing it because when you exhaust all remedies after trial, what happens is by you being in custody, whether it be both federal or state, you are allowing the appellate court to rule or make a decision on certain things that might be or might never been addressed before trial. The reason why I came up with the concept and the idea of exhausting all remedies, because when you exhaust all remedies before you go to trial, you are putting tight stringent and requirements on a prosecution in order for them to protect their position in the case. So when you get convicted and you actually in custody, the state or the federal, both the state or the federal government is making money off you regardless. So whether they hear that appeal 5 years later, 2 years later, a year later, it really wouldn't matter. And a lot of people would be like, man, why my appeal getting denied? Why my motions getting denied? You already in custody. You already got the conviction. The prosecution fight is over with. Your fight is now with the appellate judges. And so many people make the mistake of exhausting all remedies after trial. I would never exhaust all remedies after trial because it's 1,000 times harder. You were supposed to exhaust all remedies before trial. You were supposed to exhaust all remedies before you even decide to go to trial. Because when you exhaust all remedies before you go to trial, now you put yourself in a position to get the whole entire case dismissed. You got to understand that once the attorney done his job and convicting you and sending you away to prison, it's over with. So now, instead of you filing a motion for judicial review or you challenging jurisdiction or you talking about certain constitutional facts that might be a part of your case, these things were never addressed before trial. So now you're depending on the appellate court to make a decision. They don't have to make a decision. Neither do they have to rule on certain issues. You got to understand when you exhaust our remedies, the prosecution, it is up to them to defend that position. So if you challenge jurisdiction, it's up to them to combat that. If you challenge certain constitutional issues, it's up to the prosecution to combat that. If you challenging the court or the venue, it's up to the prosecution to combat that. But the prosecution don't have to combat anything through the appellate process unless you get a new trial. Now, when you go through the process or the phase of getting a new trial, you got to still understand they have to grant you that, right? And so most people get stuck in jail. I just seen one of the brothers, I forgot, Jamal, he one of the Moors, right? And so I looked at one filing because, we friends on Facebook. So I looked at one of the filings that he made and I'm like, why did they do that? Because I was kind of disappointed that they would exhaust their remedies be at the trial because I don't know. They case, I think they got represented by the public defender or their own attorney because I don't think they went in it pro se. I don't think they represented it themselves. For whatever reason, I don't know. But after they got convicted, they start sending certain petitions out to the appellate court. And I was like, bro, why y'all do that? Why did y'all do that? Why are you guys are now doing this? These are the things that need to be situated beforehand. These are the things that need to be exhausted beforehand. The position that they played on it, I was so mad because I'm like, man, brothers, you guys did it backwards a little bit. You were supposed to exhaust this before trial. Everything was supposed to be done. I don't give a damn if it's 700 motions that got to be done. Do it before trial. You have a better chance at beating any case by exhausting all remedies before trial than after trial. Because now the prosecution might not want to deal with the case. Most of the time they wouldn't, especially if they're not making money off you, especially if you're not in custody, especially if you're not a defendant going through pretrial. You get what I'm saying? I just looking, no, not a defendant going through pretrial, but if you're not necessarily in custody. So if you're not in custody or you don't have real tight bond restrictions, it allows you to do so much. So even if you want to file a notice of removal, it's easy to do that when you pretrial, or if you want to file certain issues in the court or you want to get the case completely dismissed, you do that before trial. And when you exhaust remedies, remember, you do everything. You're not limited to one motion. You're not limited to 6 motions. You're not limited to 4 motions. You have unlimited amount of motions that the court can address beforehand, right? And it will help your situation. So my advice would be to always exhaust all remedies before you go to trial. Never do it after conviction, because 9 times out of 10, you're going to end up doing all that time and you're going to be mad. So I hope this is good advice to a lot of you guys who going through y'all process or whatever the case might be. But remember what I said. Do not exhaust our remedies after conviction.